Welcome. This is the Domain Name Law Show. We're here every Tuesday. It's noon Pacific, 3 p.m. on the East Coast. We review domain name legal cases, basically UDRP decisions. Sometimes there'll be actual court cases that we'll review. We touch on some domain name legal news, then we go right into the cases. Today we have a very special show. I'd like to start off by saying hello to my co-hosts, David Michaels and Jeff Neuman. Jeff's not here today, and I'll let you know why in just a second, but we'll have Jeff back next week on the 6th, and a big show planned to start off 2026. But first I'll say, hey David, what's going on? Is there snow in Toronto? What's happening with you? Yep, you're on mute. David?
It's sunny and snowy here. So it'll get more snowy later, but yeah, it's getting a little bit too much but as it gets colder. I'm sure that RF knows what I'm talking about. Montreal's always worse than Toronto.
Yep, I hope we hear from Arif today too. Arif, it's nice to see you. Um, I'll invite you up here in a sec. We got special guest today, Igor Motsny, a friend of the show, is going to be filling in for Jeff, I say today, but actually Igor was a panelist in one of the decisions we're going to be reviewing. So it was very nice to have Igor here. Let's check Igor's microphone. Igor, how's everything going in Serbia?
Yes, hi Todd, hi David, hi everyone. Everything is going well here in Serbia. It's quite cold, no snow, not yet, but it's nice to be here. It's nice to be back on the show, and I'm looking forward to our conversation today.
Yeah, we have some good cases to review. I'm going to start off, we'll start off with a little bit of the news, but last week we talked about a decision that Jeff was involved in, and he's not here today. I was thinking he was going to be here, but Jeff is doing some traveling right now, and he's had a real busy end of the year. I know because we worked together on some things, and he's got just traveling now today, but also some big cases that he's responding to over the next week. Should have everything squared away by next Tuesday. And he's like, look, I look forward to touching base on some of my decisions, what's going on in 2026. We're going to talk about the next round. It's heating up. And, Jeff and I help companies who want to apply for a new G. But so we'll talk about that. But Jeff decided on a case that we talked about last week, Let's Lucky play.com and several other domain names. So we won't necessarily talk much about that today. We wanted to ask Jeff some questions about how he came to the decision. So today we're going to focus on a couple other cases. One is the gabler.com case that, right, on surface may seem like a simple case, but really touches on a lot of important aspects of the UDRP, in my opinion. And Igor was one of three panelists on the Gabler case. So we're going to talk about Gabler.com, and we're also going to touch on a case, PropelPro.com. So really some not simple but sort of straightforward cases we're going to deal with today. Touch on some news, get through things pretty quick today, and everybody enjoy the rest of their year. And then we got big things going next week. I'll just tell you, on the Domain Name Law Show next Tuesday, Jeff's back. We're going to have a great outline of things that we want to talk about. Try not to overload it. So today we're going a little light. And then next Thursday, Josh and I are kicking off 2026 with the DNX show. Haven't done it for 6 or 7 weeks. And we got tons of stuff to talk about there. And that's straight domain investing. I mean, we are overloaded with topics on the DNX show. So please mark your calendars next week, January 6th, 2026 for the Domain Name Law Show. January 8th, that one's going to be 10 a.m., 10 a.m. Pacific, 1 p.m. Eastern. You can check my timeline, but Josh is, loaded up with, is it alpha or is it, I forget the other word I wanted to use, but I got tons of topics to touch on with Josh, and we're going to, talk about 2025 a bit, but really just get rolling right into 2026. So look forward to seeing a lot of you there because we're really going to keep, or my plan this year was to keep the domain name law show about, the domain legal news, and DNX really explore all the other news and topics related to domain name investing, because there was some news. I noticed was Namecheap Spaceship, actually it was Richard said they had like 6 million, I think 6 million domains under management now, and that's something I was going to bring up. That's more domain news, but just a lot, a lot of growth, a lot of activity, things going on in the domain space. If it's not legal news in the domain space, then I was really leaving that to the DNX show. So today, I wanted to start off by, there was I thought it was funny, the Trump Kennedy Center. People feel different ways about it. Most people think it's like a memorial place, but the Kennedy Center should be, should stay the Kennedy Center. Trump renamed it the Trump Kennedy Center. Of course, you guys listen to the news. He's like, I can't believe it. The board, they wanted to do it. How nice of them. But anyway, this guy that is a writer for. What was the show he was a writer for, David? I have it in the news. What's the show that he's a writer for? I'll look at it real fast. Oh, it was South Park.
It's South Park.
South Park.
Yeah, South Park. Yeah.
Yeah.
And he's registered similar names like Nancy Mace 2026.com or something like that. And he's got some spoof sites on there. So.
Yeah. Okay. So thanks, guys. So it's right. So it was South Park. He was a comedy writer. He also had written for some other show. I think Mad TV. He was there back in the day, but it seemed like a young guy. But anyway, so he's one of these guys that anticipates. He said it in an article that he anticipates, and he was watching. He knew when the board was changed at the Kennedy Center, he thought maybe it will change. So he registered TrumpKennedyCenter.org, and he got the .com too. So he tries not to mess around. But anyway, when you go to the site, of course, a regular person might not know if it's legitimate or not, like the real official site. Down at the bottom, it does say this is a parody site. Let me ask you, David, and then Igor, is there what type of risks do you run when you do something like this? You need to. Well, then I'll give you my comments on why this gentleman may have a better chance of getting away with it. But if you're someone maybe without a history of creating parody sites, or it's really not your career, what risk do you take, David, doing something like this, stepping in front of an organization that made an announcement but didn't get their domain name?
Well, there's a rumor that anticipatory trademark infringement is infringement under the UDRP, and I don't believe it's true, but there have been enough panelists have transferred domain names anyways, and you lose your domain name. So what can you do? That was a big issue with the Meta domain names. Although MetaLabs.com just sold for $36,000. So it's not always the case, but yeah. So this guy, it's interesting. So this guy has TrumpKennedyCenter.org and the .com. The .org site has something funny on it that makes it look presidential. And then the .com version actually has GoDaddy's search hounds ads on there and content about culinary innovation in Copenhagen and all their junk that they're putting on domain names that registrants pay for, and they don't get any benefit from this. So there's a big risk on that domain name that's forwarded to the searchhounds.com website. I don't know why GoDaddy does that. They really are greedy. But then there's a domainer who's got the same domain names with hyphens in between them, and lo and behold, they have after nickname servers. So he's most likely to get a UDRP. What do you guys think?
Well, Igor, I wanted to ask you about that. And I just went to TrumpKennedyCenter.com, and you're right. I didn't know that GoDaddy used this site, Search Hounds. I'm sure Jeffrey's going to have plenty to comment on that. That's something new to me again. But Igor, what risks do these folks take registering Trump Kennedy Center domains?
Well, I must admit first that I didn't check the website, so I didn't look at the websites, and I don't know what's there. I need to do it after the show, I guess. But whenever you use somebody else's trademark in a domain name, there is always a UDRP risk. There is always a risk that you will get a UDRP. But this guy, he has a potential defense like fair use and parody. It can be a defense, but when it comes to parody and fair use defense, it must be clear from the website that it's a parody website. And again, as I said, I didn't look at the website, so I don't know what content he put on the website. But potentially he may have a defense, potentially, depending on the content and how he's actually using the domain name. But there is a risk, yes, definitely. And with Trump, as you all know, Trump filed quite a few UDRP complaints in the past, so he may file another one.
Yeah,
So it's funny. Also, there's TrumpKennedy-Center.org also registered. So
yeah, I want to give you two information here about. Can you hear me?
Yeah, we can, but Raghu, you just jump right in on people. But yeah, I try not to even do it. Go ahead, Raghu. Thanks for joining us.
Yeah. No. It was important for me to just jump in. I tell you why. I was watching a news a couple days ago, and I heard the Kennedy family are objecting why Trump is adding to this, because they have a Kennedy Center and he changed the name and added his own name. And the Kennedy family is objecting that in the courts right now, or they're doing everything about it. They don't want Trump Kennedy Center. Okay. They are literally saying this has nothing to do with this politics or presidential thing. And something like this type of news, you can go and dig it. It's very fresh news. So forget about this domain. It is worthless. The Kennedy is claiming the family or the connection with this Kennedy Center. They're saying even Trump is not allowed to add name to this Kennedy Center. So just to let you know that. Yeah. So just to give
Raghu,
you that
I wanted to say, of course, I'm on top of it. Yeah, I see. I'm very familiar, and I know not only are the Kennedys, the family, upset, and they filed a lawsuit, but they're saying, like a lot of others, Congress has to be the one to change the name of this, if at all. And so, yeah, they're definitely trying to tie some things up in the courts. What I think, there was a lot of people scheduled, artists scheduled to perform at the Kennedy Center, and who, Juan Manuel, or whatever his name is, who does the one play, Hamilton. It reminds me of Arif. I say that Miranda. He basically was going to be there 6 weeks with it's the 10-year anniversary of Hamilton. But and people, that's bull. The people get mad on both sides. It's political because of course Trump renames it. But the point is, I like the idea of. Yeah, go ahead.
Not only that, Kennedy family or whoever is connected with that center they are threatening. He said, if that happens, we're going to pull out all the connections of the history of Kennedy from a presidential palace or whatever, the White House or whatever exhibitions or whatever is something to do with the Kennedy. We're going to pull out everything, demand everything back from the government. That's exactly the threat they given to the Trump.
Yeah. Well, the thing is about this whole thing, anyway, there's been a war on each side since Trump has come around, and people that don't like Trump, of course, they call it TDS on the right. And just some people that don't, but I guess the point is there's been a war in the U.S. going on for the last decade, the right and the left. Nobody wants to call it that. Everybody still wants to say, let's get along. And the ship has sailed, okay? So there's going to be, the new board is going to sue people that decide to cancel, and then they're going to get artists that continue to cancel. Basically, it's the Hatfield and McCoys. The sides don't like each other, okay? And it's really from the top, the leadership on both sides are like, listen. So, we're going to see. To me, I don't think it's nice. I mean, sometimes it's interesting because of the legal proceedings. But like I said, I like that people are allowed the free speech of, okay, now, as long as it's not breaking, if you have a contract and you get penalized if you don't show, then you get penalized, could be monetary damages. But if you aren't breaking your contract and you're doing it as a statement, I say go for it, and that's on both sides. And then if the new leadership or the new board of the Kennedy Center, the Trump Kennedy Center, wants to think they have standing to sue, and then they're going to sue, then go for it. But yeah, it's like, listen, as long as people are, I guess, fighting it out legally and not in the streets. But sometimes it's terrible to get into a fight either way, whether it's
Yeah. So therefore, this domain of honing this Trump and Kennedy, totally garbage. It's going to be, without even looking at it, the panel or UDRP or court is going to toss that garbage domain out. This is my prediction.
Yeah. So who knows what's going to happen with the name? We're going to get onto our news so we can get to our cases, but we're going to follow, what's going to happen not only with the name but with domains that are related to it, and will there be some UDRPs that we end up reviewing here on the show? Another story, a famous company, Lego Holdings filed some lawsuits against um, somebody registered legoflorist.com, and then Lego flower, it said bouquet and it was with a G. They misspelled it, but anyway, I guess Legos does not only just have a trademark for their, these little Legos, these little whatever, we know what a Lego is, but they also do have these flower arrangements made of Legos, and it's something that they have a trademark for. Anyway, this individual registered these names, legoflorist.com and so on. Lego files a UDRP, wins the case, but the person did respond informally and just said, "Listen, I'm a fan of Legos, and I wanted to promote these floral arrangements created by Lego." Well, the panel said, "Yeah, you can't. That's exactly what you can't do. You can't, you know, um, plan to benefit from their mark." And the person said, "Well, I haven't even done anything commercially yet." So I guess I wanted to ask David and Igor. It's a weird one, but so Lego wins. It seems normal for them to win. But when someone registers something like this, is there any chance of them, winning if they're doing something non-commercial? We talk about fair use all the time, but so with legoflorist.com, any chance that person could have been successful, David?
Only if he was actually using the actual Legos for like the flowers, like he was actually delivering flowers made of Legos. And that's a stretch, but it's a possibility. Now there was a case that went to court and settled for millions of dollars involving IKEA. And this guy had a how-to website on how to build IKEA furniture, and everything that IKEA sells, you have to assemble it yourself. Well, this guy had this really great website on every single item they had. He showed you how to build it in a video and detailed instructions. And he was so popular, he had millions of views every year, and they wanted his domain name and his website. He sued, he got the right expert witness, and he got millions of dollars out of it. So there is a possibility, but you have to do it right. And it was, the guy was making money from it. It was his job.
Yeah, I sort of remember that IKEA. Igor, quickly on this. So, what's your take on fair use if someone's going to use like Lego in their domain or in their business or in their advertising at all? When can you use, fairly somebody's well-known trademark like Lego?
You can build like a fun website on this domain name, and then this will be fair use. But again, there are a number of factors you should consider, and that the UDRP panelists will consider. And first of all, I would like to say that it also depends on the provider, because if it's a WIPO case, then the WIPO panelist will follow the WIPO overview. And the WIPO overview contains, special subsection, subparagraph about fan sites, and basically the main names used for fan sites. And it says basically, yes, if it's a genuinely fan website, then it's okay. But then you also have to look at the domain name composition, because if it's identical to a trademark, then this may not be okay. But if it contains like an additional term, something like trademark plus fan or trademark fan site, then then it can be okay. So there are a number of factors, but the most important factor is actual use. So if you actually use it for a fun website, as David was saying, that maybe you write about Lego, write about your stories, with Lego, how your kids love Lego, and put some pictures, provide some history, then I think you can argue that you're doing this non-commercial fair use. But if it's something else, then people can say just anything, but you have to provide actual evidence, and it has to be non-commercial fan side if you claim it you're a fan.
Right. And if it's non-commercial, you definitely have, I say, stronger, maybe even more defenses. You guys would know, but I know you can make it commercial if you're only, say, you're only, especially if you're authorized, but only a reseller of Lego and so on. I wanted to, get to our cases today because it's nice to have Igor here, who was a panelist in the Gabler case, but Igor also represents complainants and he represents respondents. So if you are in a domain dispute, whether it's a UDRP or whether it's a court case or whether you just get a cease and desist and you think, geez, I'd like to have some assistance, reach out to Igor. You can follow him here, right on X, but his information is easy. If you need it, you can reach out to him or even reach out to our show, dnlshow.com, and you can get Igor's information from us. But there's so many cases that are coming down the pike, I guess. I don't know if it's a pipe or pike, but I was just looking today. There's this VDFT.com was denied. That was a case that was denied. Davidson.1 was denied. But people are just, I think, there's a lot of complainants out there. A lot of companies that are thinking, I don't have my name, I don't have my acronym or my initials, or I don't have all of them, like Davidson.1, because the college, Davidson.edu, went after this Davidson.1 and was denied. But we're just seeing companies going after their domains via the UDRP, basically trying to obtain their domain name of choice via this administrative hearing called the UDRP. So as companies become more familiar with it or know about it, because as soon as they don't have a domain name, they talk to their lawyers, or they do some investigation themselves and say, hey, can we file one of these? And then, or where they say, can we file an ACPA case? And they get some legal help. And then the lawyer tells them, well, this is going to be expensive. We can try this for $1,500, between $1,000 and $1,500. And I'm saying tons. It seems there's so many cases. So next week, I'm going to pick out a few interesting cases that we're going to cover. There's just no shortage of what I wanted to get at. Finally, before we get to our cases right now, I just wanted to mention that I said earlier, if you're going to apply for new GTLD and ICANN's next round, visit tldstrategies.com and set an appointment with Jeff and I, and we'll let you know how we can assist you. I did see, I believe it was on dnw.com, that there's a Kickstarter that was created for this .meow extension, .meow, and it was a new G. Basically, this company, I believe in Belgium, was approved for the assistance program, meaning they're going to get like 75 to 80% off their application fee, which is $227,000. But there's a lot of other fees when you file. There's other fees basically you're going to run into, and costs when it comes to managing your new extension if you do get it. So this company went on Kickstarter and is trying to raise some more money to help them apply. I thought that was interesting. Maybe we'll touch on that next week, because we're going to touch on the guidebook. The new GTLD guidebook has been released. Talk about that when Jeff comes back a little bit. And then finally, the ICA Meetup is in 2 weeks now. So I really look forward to this ICA Meetup. I saw there's some new members. I don't know if I'm supposed to share, but I saw Tony Names, who we see on here a lot on X, posting about sales, and he's like a new hotshot domain investor. I mean, basically successful in my opinion from what I see. And Josh is friends with him, or at least knows him a lot better than I do. I don't know him. I only know from Tony from his posts. But he did mention on X that he's going to be at the ICA Meetup in Vegas I'll tell you, I really love talking with my colleagues, domain investors. Like I said, the ICA is a domain industry organization because there's a lot of attorneys, the domain lawyers that are members there, and they may or may not be domain investors as well. But registries, registrars, GoDaddy, Unstoppable, and Dynadot, Namecheap, Namebright, those guys over at Turn Commerce. But so a lot of, all the executives and a lot of the leaders and their executive teams are there. And I'm talking about from, like I said, from the registrars, registries, and then of course the brokers. All the brokers are members, pretty much. And then the majority is still domain name investors. But what a great group of professionals. And if all of us know, most of the people, especially if you're a domain investor, it really usually is just part of your life, meaning you're a professional in other areas. You might be there's a few guys that are just full-time domain investors. Stephen Kennedy comes to mind when I think of, he was a domain investor when he was young in college and turned it into his profession. He's pretty much one of the few that I think domain investor pro from a young age to now, and he's nearing 40. Okay, so, but most guys like myself, we come from other backgrounds and we still maintain those other backgrounds. So it's a lot of business people there. Great to build relationships when it comes to, if you're an entrepreneur, you're building a business. If you're looking for partnerships or you're just looking for motivation and colleagues to share with. Okay, so that's coming up January 15th through the 17th in Las Vegas. Go to internetcommerce.org. Matter of fact, go to ICA.Vegas, and just shorter, but so worthwhile. And I mean, people with the excuses for not, if you're a domain investor at all, unless you're just broke as a joke, and that's not bad. You're broke as a joke. You're a new domain investor, young person. You just simply can't afford even $25 a month to become a member. I understand, but outside of that, if you've been a domain investor for a long time, just excuses to not be a member of of this organization. Great organization, great board leadership, and going to be a good time. All right, so our first case today is going to be Gabler.com, Gabler.com. I think what David and I will do, I'm going to mention a few things about the case, but David and I will sit back, let Igor talk about the case, the facts surrounding the case, how he and the panelists came to their decision, and then David and I will ask him some sharp and pointed questions. But no, I'm glad you brought up, Igor, about WIPO, the WIPO overview, because we're going to touch on it several times today, and we'll explain more of what it is. But anyway, so this Gabler.com case was a case where the complainant is a German company, a big machine company called Gabler, and they filed this case against this domain investor, Stanley Pace, who was represented by John Berryhill. Now, I'm going to lead off by saying, Igor, I noticed that in the summary of this case, they mentioned that the complainant didn't mention much about their own company and that the panel had gathered info about the complainant from the internet. So I wanted to start off asking you, obviously tell us about some of the facts of the case, but then, lead into how much, as a panelist, do you research into the complainants, into the respondents, if the information is not provided to you in the complaint or in the response. So I'm going to send it to you. Tell us about the facts and what type of investigation you did to get more info on the complainant and respondent here. Thank you.
Yes, thank you, Todd. Well, basically, this case, you pretty much explained it. It was a German company, German naval equipment company against the domain name investor. And well, the problem was that the complaint was very, very short and gave us very little information. So we didn't even have information about the complainant. I'm not even sure they provided like a link to the website of the complainant. They did mention some facts, some very basic facts, but we just had to do some additional digging just to understand, what the complainant, who they are, what they do, and just to get some basic understanding. But basically, just do some social, just basically some Google search. That's all we did. And what was also an issue in this case, the complainants counsel uh, basically relied on trademark application, on a pending trademark application, and on a business name right. And as we all know, that it's not enough to establish the first UDRP element. You have to have a trademark, either registered or unregistered trademark. So they didn't claim common law trademark, but they did provide a document with some information. And when we actually checked that document with that information, it actually became clear that the complainant had a trademark. So they did have a trademark, but they kind of didn't know that they had a trademark. So we checked the European Union trademark registry, and we found the trademark. So that was kind of independent research that we all did. I think each of us did a bit of research. And again, I didn't have any issues with finding the trademark. They didn't expressly mention, but it was in the document they provided to us. And normally, in normal cases, I just do some basic research. I don't do complainants work or respondents work, but sometimes I just want to verify if complainant says its trademark is well known and it doesn't provide much information. I would do maybe some additional search just to check how well known it is. And if there is no response, and if it's like a passive holding case, I would normally check possible, let's say, if there is no non-infringing use of the mark, let's say, of the domain name. So that's kind of very basic research I do, and maybe just verify some facts. And if I have any doubts, of course, if, for instance, complainant claims something and I'm not sure if it's true, then there's always like an option to issue a procedural order, or you can just do some research. So this is kind of search I do as a panelist. But this was a three-member case, so we had some, let's say, internal discussions among ourselves, what we should do and what we shouldn't do.
So did they raise the fact that they had a pending U.S. application and it was on the supplemental register, and maybe their earlier registration was also in the supplemental register because it's merely a surname? Did that come up?
No, it was European. They didn't have a U.S. trademark registration, or at least they didn't mention any U.S. Maybe they did have, but I don't know. They only
did,
mentioned
sorry,
they did. They only mentioned like European Union trademark application, and they provided a document which they claimed was a trademark application. But when I checked the document, it wasn't like a European Union trademark application. It was an international trademark application filed under the Madrid system of international trademark registrations. And that Madrid trademark application was based on an EU trademark registration. So they actually did have a registration, not an application, but somehow they didn't know what they had. So that was very, let's say, interesting fact about the case. So it was European.
Yes. It's interesting that they had a U.S. registration on the principal register in 1986. They applied.
Okay, so they used to. Okay, they had.
And that expired in 1994, and that was on the principal register. But their latest application, it has been approved on the supplemental register because it's merely a surname. So that just goes to show you how these 1980s era trademarks were issued haphazardly, incorrectly a lot of times. So they should be, more scrutinized more clearly. I'm looking at the WIPO brand index. There are a whole bunch of trademark holders for Gabler, including like companies in Germany, all over Europe. So it's just not them in Europe. There's a whole bunch of companies in Europe. But they did have something in Austria that expired years ago. So I guess they don't maintain their trademarks very well. I think that's their problem.
Probably, I think one of the problems definitely, but the other problem was for some reason, for this UDRP filing, they didn't even identify which trademarks they have actually. They only identified one trademark, and they claimed it's a trademark application. Well, it was a registration actually, but that was, let's say, a starting point of the whole thing. But then there were some other things about this case. But clearly they're not the only, and not even let's say the main user of the term Gabler There are many other gabblers, and the respondent mentioned this in the response. Basically, the respondents council listed, I don't know, hundreds of other companies using Gabler, hundreds of other holders, trademark holders of the Gabler mark all over the world, including Europe.
You guys both brought up some good things here that I want to have the audience reiterate to the audience to, an educational moment. And it was for me. So we're talking about the domain name gabler.com. And this big company, this German company that was the complainant, came in and right, Igor, in their complaint, and what I got to see in the summary and then through the summary that the ICA also did was talk about we have this European Union trademark. We also had filed, we have an application for this U.S. mark, and then David brings up a great point that they used to have a U.S. trademark in the main registry, but they let it lapse, and that shows you how important it is to maintain your trademark, because now they reapplied, and like David said, it goes to the supplemental registry, which that just is basically saying these people are doing business as this name, but it's really unprotectable. So they can do business under this name that other people use and other people can use, but it's not really something that they can prevent others from using. It's not something they can protect as their own. So one couple things I wanted to mention. One, very important to maintain. If you were lucky enough to apply, like David said, in the 80s, and they go ahead and approve and register your mark, and it's in the main registry, well, you really want to, obviously maintain your mark. The other things about the UDRP that are important is you cannot, a pending trademark application is not sufficient. So Igor brought that up. A pending trademark application is not sufficient. So we say that again. If you apply for a trademark and then now you're coming over to the UDRP and saying, hey, look, I applied for a trademark, that doesn't do it. You have to have a registered mark, or you have to show that you really have common law rights to the mark, which is, not necessarily easy. You need to really submit plenty of evidence showing you have common law rights. Additionally, a supplemental registered, or a name that's in the supplemental registry, is not sufficient either. So if you say I have my trademark registered and then it's really registered but it's in the supplemental registry, that's not sufficient to have standing to file a UDRP. So that or an application is not sufficient. So in this case, you guys really, Igor, you and the other panelists did say, okay, you guys did have this European Union trademark, which is sufficient. You guys are really almost unclear, confusing about your trademark, but you guys went ahead and gave them the standing. Okay, so they did pass the first prong of the UDRP, that they did have a trademark, so they can go forward. Now, about legitimate use, I think this is really important here, because you bring up WIPO Overview 3.0 Section 2.1, okay, because we're going to talk about it, which is very important to domain name investors, and that is trading and selling of domain names is legit. So, Igor, go into a little bit about how you guys decided, and what John Berryhill, he was representing the domain owner in this case, what evidence John submitted to make you decide that this domain owner did have legit use to this name.
Yeah, I mean, first, as you rightly said, that maybe we could have just denied this complaint on the first element, for the lack of standing, because really they didn't even argue that they had registered trademarks. So we had to do some digging, some independent research to actually find out that they did have a trademark. But that was our point. We decided, okay, let's give them a pass on the first element, but then let's deal with the second and the third elements, because actually they're more important in this case. John Berryhill basically argued for his client that, my client is a domain name investor. He's specialized in family name and surname domain names. And he has a history of investing in family names and surnames. Gabler is a common surname in Germany and in some other countries. And he provided some evidence and that Gabler is a common, let's say, pretty common surname and there are a number of users using Gambler all over the world. And basically, he claimed legitimate interest of domain name investors. Uh, and we agreed. We cited to WIPO overview, and WIPO overview says basically that yes, it's okay to buy and sell domain names that are, let's say, generic words, dictionary words, and I think acronyms. But basically, this principle now extends to other, let's say, to brandable domain names that are not necessarily dictionary words, and to surnames as well. So it's not only about acronyms and dictionary words. So we supported legitimate interest of the respondent, and we wanted to deal with all three elements. And I think, in my opinion, in particular, it was important to deal with the second element, because again, we could have just skipped the second element and denied the complaint on the third element, because it was clear that there was no bad faith registration, bad faith use. But we wanted to deal, with all UDRP elements.
Yeah, David, go ahead, David.
So I have a question for you, Igor. So on the first element, you guys probably debated a little bit, but how much common law usage did they show in their application? Was there anything to show that, to substantiate that they had common law rights beyond, their actual registration? Because the registration itself may not be sufficient.
No, there is nothing on common law right. They didn't allege common law trademark right. They said that we have a business name, but again, we said in the decision that business name is not a trademark. It's not enough. Again, you have to claim common law. They didn't claim common law trademarks. So the only, let's say, trademark they had was this European Union trademark that we found, basically. That was mentioned in one of the annexes, but that was not properly identified by the complainant as a trademark, but it was mentioned. But no arguments of common law trademarks whatsoever.
And we know people in this room are smart. They've been around, and we use that term common law trademark. It really just means a real world trademark, meaning you don't have it registered with some government or even a state, but well, you could, but basically common law means real world. You really did use it. You really are known by that name. You really sell a product or a service under that moniker, under that name, and you can prove it. You usually prove it by showing, look, here's advertising that we do under that name. Here's checks that we've received to that name. And, here's the product name. Basically, just real world examples of how you've used the name in commerce and you've established a trademark. And we say, that's why we say common law. It's a real world. You haven't got it registered. You don't need to have it registered. The reason you register here in the U.S. and around, you get additional protections. Plus, it's easy when someone says, do you have a trademark? You can just spit out the registration number, and that means, okay, so some examiner, some lawyer at the trademark office already researched your usage of it or your common law usage of it, and has officially now let you use the little R with the circle in it, all right, instead of just the TM. But so there's, I know people in here know, but it's worth, saying again, because when people are common law mark, that means any of you doing business, listen, you're establishing a trademark if you really are using a name, and it doesn't be a domain name, just a name for a product or a service, and that's how people know you, by that product or that service, and that's how they pay you, and so on. All right, Igor. So about the that WIPO overview 3.0 section 2.1. So briefly, tell me. I mean, okay, WIPO has that overview, and it was important that you said it sort of expanded, meaning, it was, if it's a generic name, or if it's, a dictionary word, or it's a surname or an acronym, those are protected. And now it's sort of broadened to be, if it's a made up word, like you say, a brandable, and people believe, domain investor is buying it because he believes it's such a good, fly agent, I don't know, some two words together that you think it's not a dictionary word, but it certainly is potential for a brand to name themselves this in the future. That now is considered, it can be considered a name that's legitimate for a domain investor to invest in and has rights to. When it comes to, there was something else about I lost my train of thought there. Oh, about WIPO, their overview, as opposed to Jeffrey, our co-host here. He's on over at the forum. So WIPO has this overview. What does the some of the service providers, the WIPO equivalents in Europe and the forum have in place of the overview? What do they use, and do they ever look to the WIPO overview? Or, tell us, why WIPO has this overview that sort of assists panelists and really complainants and respondents in answering. But do the other service providers have similar documents or overviews?
Well, WIPO overview is a very comprehensive document that basically is kind of a guide on UDRP and on these various UDRP related topics and on all three UDRP elements. And it basically gives you many answers to many questions. I'm probably wouldn't go as far as to say that it answers every single question, but it gives you pretty good understanding of what you can expect if you're a complainant or if you're a respondent, and in particular if you're a complainant or respondent before WIPO. But WIPO overview is widely used by all 5 UDRP providers, not just by WIPO. So let's say whenever someone asks me about the UDRP and maybe some kind of basic document, how to get some basic understanding and basic knowledge about the UDRP, I would normally refer this person to the WIPO overview as a starting point. So it's a good starting point. Again, when it comes to WIPO cases, to arguing cases before WIPO or deciding cases before WIPO, yes, you should refer to WIPO overview. So whenever I argue a case before WIPO as a complainant's counsel or as a respondent's counsel, I refer to WIPO overview. I look at the WIPO overview and I cite to WIPO overview provisions, because this is something that the panelists will have to take into account. And I know that WIPO panelists are encouraged to cite in their decisions WIPO overview rather than cases, rather than actual decisions. But when it comes to other providers like the Czech Arbitration Court, and that Gabler case was the Czech Arbitration Court case, or the forum, then they all use, and the panelists all use WIPO overview, but then you have, let's say, some additional freedom to use any other sources. And let's say, that Zach Maskovich and I, we're working on this project called UDRP Perspectives, and some forum panelists, for instance, they cite to UDRP Perspectives in their decisions, or you can cite to maybe to Gerald Levine's book, Clash, Trademarks and Domain Names, or any other resources. So when it comes to other providers, I would say there is more flexibility, but when it comes to WIPO, WIPO overview is a must, is number one source.
Well, thanks. And now it makes a lot of sense what you said. You're not prevented from using any source to where you get it. And then some sources are obviously, like you said, Jerry's book. Some sources are more relied upon or people consider more authoritative, nothing more than the WIPO overview. And I was going to think, when they had that WIPO, the 25-year WIPO event, what I thought would be funny is when at the event, when they have things, when they should have had on the restroom door when you're leaving, remember to WIPO. Okay, I'm ruthless and rude. Okay, so 2 more questions, Igor, about this case, and then we're going to get on to our next case. Okay, I wanted you to tell me about the complainant's unsuccessful attempt to buy the name from the respondent, because I didn't see that in the summary. So that's one thing. Tell me about the complainant's unsuccessful attempt to buy it, because you mentioned, and this will go into the final question, about why you, as a minority on the, and I mean that one opposed to the two, a minority on the panel, that you ruled, that you said you would have ruled for a reverse domain name hijacking, because this was also an example of a classic Plan B, that they unsuccessfully attempted to buy the name and they filed the UDRP. So tell me about this unsuccessful attempt to buy the name and how and why you would have ruled RDNH.
Yeah, so I mean, writing this decision, like, let's remember, was not easy, because we were trying to understand what we should put in the decision and what we shouldn't put in the decision. And so some facts of this case went into the actual decision, and maybe the other facts went into my concurring opinion, because it wasn't like a dissent, because basically we all agreed on the outcome. We all denied the complaint, but I wanted to say something more. So okay, I put some facts into my special opinion, so to say. And yes, the complainant argued in its complaint and in its supplemental filing, because the complainant also submitted its supplemental filing after the response was filed, but before the panel was appointed. The complainant said that, look, we tried to buy this domain name from this respondent. He didn't respond. So that's why he was definitely acting in bad faith. Because even if he's saying that I'm a domain name investor, but if you're a domain name investor, then you should respond to any offer that you receive, from someone. So that was kind of his logic and his argument. And I think it was also interesting and important for domain investors to know that the complainant mentioned, I think in its supplemental submission, that okay, you're saying you're a domain name investor, but domain name investors, their activity may be lawful, it's maybe okay, but you don't have a legitimate interest under the UDRP, which is wrong, clearly, because there are hundreds of decisions, thousands of decisions which confirm that domain name investors can have legitimate interest. And even WIPO overview says that yes, you have legitimate interest as an honest domain investor if you don't target. So that was one thing in the complainant submission. They tried to buy domain name, they didn't receive any response, and then they filed the UDRP. Basically, that was the main motivation. And with regard to my opinion, I wanted to maybe say something extra, because we all agreed that we should deny the complaint, and my co-panelists believe that maybe that's enough and let's not go any further. And I felt that I should say something, because the complainant was represented, was professionally represented, so there was a lawyer. And yes, looks like this representative didn't really have much of UDRP experience. And I understand that UDRP is kind of a very specific subject, but still, the UDRP has been around for 25 years. There are so many resources. You can always go and check WIPO overview and understand when you should file a complaint and when you shouldn't file a complaint. And to me, maybe lack of experience doesn't justify like a poor complaint. And I believed, again, personally, that well, I should say something. I should say that this complaint deserves an RDNH finding, and I provided a number of reasons for RDNH finding. And so basically, that was my logic, my motivation in writing this concurring opinion. And I just said that this complaint shouldn't have been filed. Let's put it this way. It didn't contain proper arguments. Some of the arguments were kind of contrary to the logic of the UDRP. They were against case law, against WIPO overview. And well, initially the complainant believed that the registrant is a dead person, someone who died like 10 years ago. And the same argument, they repeated the same argument even when the respondent's identity was revealed. So there were very strange things, let's say, that we saw. So that's why I said that yes, this deserves an RDNH.
And of course, a lot of us domain investors, I agree 100% here. For one, Igor, this is a big company with representation going after the name GABLER.com. So they're not going after a name Gabler. They were on Gabler-naval.com, Gabler Naval, as in naval as your belly button, Gabler Naval. So if you're going after Gabler-login.net and there's no response and the name is really not valuable, basically you probably have rights to it, I could see them being a little reckless, meaning not having a complaint that's really complete. But when you're going after someone's asset, like some of these companies, big company with representation, trying to take someone's property, GABLER, in many cases, it's even much more valuable names than that they need to be held to a certain standard. So I'm very happy that you added that in there. And maybe they'll learn a lesson. And maybe in the future, even when they're going after, they can't go after, I guess they could go after the same domain again if there was substantially something different with the case. But anyway, going after a different name that has their mark in it, that they'll know, have a complete case. And I think we're just seeing this happen more and more recklessly, trying to just take domains from folks. This next case So that was a denied complaint, denied, as Igor mentioned. They found that there was legit use for it, and there was no bad faith registration, so they denied the complaint. And then Igor even added additionally that he thought RDNH was reasonable. This
Yeah,
next
Todd,
case,
sorry,
yeah,
can I just briefly, just to add on this very last thing, because since you mentioned that, I hope this will be a lesson. And, I felt that if I add this concurring opinion, a special opinion in the end, that there is a higher chance that, people will read this decision maybe carefully, and they will at least, take this into account next time. It can be any other lawyer, can be the same lawyer who filed this complaint. But, sometimes I just get this impression that no one cares really about UDRP except very few kind of geeks, you know, who talk about domain names and the UDRP. I'm one of these geeks, and I take the UDRP very seriously, but many other lawyers don't take it seriously. So I think that, if you put something extra in a decision, then there is a chance that, more people will read the decision. That was also kind of my motivation.
yeah, and then they'll know. Well, they'll know not to choose you if it's a complainant. They'll know. Geez, no, he just will. He's serious about this. But it is true. It's an important part of these digital assets, and really all these defenses in the UDRP and all the facts that happen in these cases. Basically, a lot of this stuff is used later on when there actually is a court case. So it's important to, I think you really did a favor to the complainants here by, one, that nothing happened, but they know when you do file in the future, and not just them, but any complainants, get your stuff straight and don't, file a fraudulent. This eventually will come back and harm you. And right now, there's not a penalty for RDNH, but it certainly doesn't help, And then I think it really emboldens other panelists too to know, what, no one really asked for it, but should I be looking at that? Is this a case where the complainant is basically abused the system by filing it? This next case is exactly that. And David, I want to have you sort of talk about the company that filed this case. It's propelpro.com. PROPEL.com is the disputed domain name. The company that filed the complaint is Propel Pro out of New York. It's a Delaware, incorporated, but it's a New York company. And they filed it against this company that seemed to be Educate 360. That's, I don't know if they're around anymore, but they still were the registrant, and they're out of Massachusetts. So David, tell us a little bit about the complainant, this case. I'll already ruin it. The respondent did not reply, but tell us about the complainant, why they filed, what they do, why they filed, and how this case turned out.
So the complainant is Propel Pro, and they are in the athletics business. So they train athletes. They have a Facebook page, offer pro coaches. They have a LinkedIn page, but this was all created this year. They operate, it looks like, on propelpro.world, which is not really like authoritative domain name. That .com is obviously the one in dispute. That was registered in 1994. The current owner acquired it in 2015, and it was organized under Indiana law. So the complainant applied for the trademark application, and it's not registered yet. And even if they had a registration, it's no good because it doesn't help them because the name was already registered long before they even existed. So they can't even claim common law rights. But their application says that it's an intent to use application. So they don't actually have any use. There's no common law usage. And all it is a pending application. That gives them no rights to swipe an existing older domain name at all.
Well, one thing I did notice that they did hand register Propel Pros with an S.com, and I don't know. I think they got that in 2024, looks like. But okay, I believe they did. But right, so they're also on. You said propelpro.world, but they wanted that singular name. They filed the UDRP, and they only had, like you said, they had an application for this trademark, didn't provide any evidence. They did say, but we were doing business as Propel Pro prior to this, so we do have some common law rights, provide no evidence. And even if they did, you mentioned it, this name was registered a long time ago, but then was re-registered by this particular registrant in 2014. Okay, so it was a single member panelist, Scott Blackmer, said, hey, you don't even have a trademark, so you don't have standing. I'm going to go ahead and throw this out. So I can see a complaint denied, but he did go further and ruled an RDNH. And we'll talk about the WIPO overview that he touched on here too. But Igor, did you happen to have a chance to look at this case, and what's your thoughts on this complainant filing this case without a trademark, and then Scott Blackmer's decision here?
Yes, I did look at the case, and I agree with Scott Blackmer's decision. I believe that this was, yes, obviously clear denial, and this again deserved an RDNH finding. Again, the domain name predated complainant. The complainant didn't have a trademark in the first place. Yeah, they had only a trademark application or applications. Then I think they tried to allege like common law trademarks or unregistered trademarks, but they didn't provide any evidence. And the domain name predated this application by like 10 years. And this was actually our case in Gabler as well, because the domain name registration predated the trademark. So I think all elements of RDNH, or major elements of RDNH, were present, and Scott Blackmer was absolutely justified in finding RDNH. And I think what was interesting about that case, it was a default case, so there was no response filed. No response, and the complainant was represented, and in that case, in this the complainant was represented by a very large and very reputable U.S. law firm, which I think is kind of surprising that they filed a complaint like that one.
Important that you bring that up, David. I'll let you make a comment. I'll be quick here. So this complainant has this big law firm, and the big law firm's thinking, you know what we have on our site here is there's no active website. So we're going to go ahead and bring up this passive holding doctrine that's WIPO in the WIPO 3.0, section 3.3 I wrote down. But basically, because the complainants always believe if there's no active website, passive holding is not legitimate use. So we'll bring up passive holding. This is what I'm thinking that the complainant's lawyer said. So we got two things that could go for us. One, the passive holding, because there's no active website. And two, if they don't respond, that's going to be hugely in our favor. And those two things that they made, the argument for the passive holding, the respondent did not reply, and it didn't fool Blackmer at all. He's like, no, you guys were hoping against hope. But David, how did you view this? What do you think was truly just an easy RDNH ruling?
Oh yeah, and I wonder why the decision does not even mention the particular lawyer's name that represented the complainant. They just say Kenobi, Martin, Olson, and Bear. And that's a big law firm that specializes in patents and trademarks. I used to know them as being based out of Newport Beach, California. I don't know if that's their only location, but lately they have been more aggressive. I know they have offices in the East Coast also. So I would say that some of those lawyers are less than scrupulous given their past history in domain name cases, and this might be another example of something that should be sent to the state bar, and disciplinary proceedings are necessary.
If this would have been Don Osborne, I'm wondering, and there's just no case, no panelist could really, in my opinion, rule for this complainant because of the dates involved. But anyway, if they made this type of case and there was no reply, there's some panelists that just go through the cases fast that could have been a ruling in the favor of the complainant. I think that's what they were hoping. Hey, it's wonderful to have Nathan Parker here today. Hey, Nathan, thanks for joining us. Hope everything's well with you. What's going on?
Hey guys, yeah, everything's going well this end of the world. The weather's nice. So you're not going to really hear too many complaints. Been enjoying a little bit of downtime before I get back into it on the 5th. I'm not sure if you heard me. It's just said that, yeah, everything's good this end. Enjoying a little bit of downtime. Another big year, another huge year in the planning. New broker on board next in February 1. So really, really excited and loving life.
Well, Nathan.
So Nathan,
go ahead.
In Australia, do businesses normally shut down for the Christmas holidays? Is that a normal thing?
Yeah. Generally they do. We generally, if a business will generally wind back, the week of the 20th, that week. Um, some, depending on the industry, some will go back, say the 5th. We go back on the 5th. We have a skeleton staff because we're a global business. But yeah, as a general rule, some, like a lot of the trades won't go back till like the 15th of January.
So you got
Wow.
somebody new
Yeah,
starting.
I have cousins in Australia, and they go to the beach. They have picnics around Christmas, and it's a good way to meet up with family because it's so hot there at Christmas time.
Well, Nathan, I know it's early there. I know there's several time zones in Australia, though. What is it? 8 o'clock? Just after 8 a.m.?
Yeah, it's nearly 10 past 8 in the morning.
Okay, so I'm hoping that you can join us on the investing show DNX, even though it's a little bit earlier. It really starts, if it's 8 now, we start at 5 in the morning, but you could be the second hour at 6, 7. We go for 2 hours, on Thursdays, Josh and I, the DNX show, but it's really made to order for you as general manager, as the head of the aftermarket over there at Above. Well, let me ask you, are you going to ICA event? I know you were just at NamesCon. Are you going to be in Las Vegas here in a couple weeks?
At this stage, no, I'm not.
Okay. No, I mean, you're doing a lot of traveling, but so next Thursday, we're launching 2026 on the Domain Investing Show. We call it the DNX Show. That's on Thursdays. So I'm going to send you a message just as a reminder, but it's so early for you. The second hour would be starting at 6 a.m., but maybe 6:30. I know it's early for you, but the thing is, I want to hear about your year, 2025, your predictions. I heard a lot of predictions on DNW the other day, out of the same horse hockey, but your predictions as someone with their, we say feet on the ground, or I don't know, you're on the front line. Your predictions for 2026, what you're doing to, to really make 2026 better than 2025. Some of the actions you're taking to improve results, but really in about quickly. So you got someone new that's joining your staff, is that what you said? You got somebody new?
Correct, yeah. So I've got a new broker starting on February 1.
Interesting. I mean, it's great for them to be part of a great team, and they're awful lucky. Is it anybody we know from the business or somebody that's new to the space?
I'm not going to let the cat out of the bag just yet.
Okay, so we know them. Okay, so otherwise you'd say no. Okay, so no, that's interesting. I'm glad to hear. And boy, like I say, how lucky to join such a great team. And then you too, I guess you're on the team. So what a great group of people there. But no, they're lucky. I look forward to that. Well, let me going to wrap up today. So everyone, please join us next week. Domain name law. We're every Tuesday, noon Pacific, 3 p.m. Eastern. We're really going to get rolling next week. Jeff's going to be back. 2026 is starting, and then next Thursday, the DNX show. Josh and I do that. You can watch my timeline and you see the times and all that. You guys know this stuff. But I really want to thank my co-host David today for always being here and doing what we do. Igor, thank you so much for staying up. I know right now, well, heck, it's after 10. It's 10:10. Igor's finally thinking, okay, so he had some.
Thank you. Thank you, Todd. Thank you, guys. And it's always my pleasure. And Happy New Year, everyone.
Thank you, Igor. And like I said, anybody needs some legal assistance, you can always reach out to the show here. David helps with trademarks. You need some help, establishing. Basically, if you just want to talk about if you've established a mark, whether it's a common law mark or now you're ready to apply, you're ready to uh, send in an application for a U.S. mark, for a Canadian mark. David can help you anywhere around the world. But anyway, reach out to David Michaels right here, host of the show. And then, of course, Jeff Neuman is super valuable, but we'll promote him next week when he's back. But also, like I said, follow Igor. You can reach out to him if you're a complainant, if you're a respondent, or if you just want some legal advice on domain name disputes. So thanks to those who joined us today in the audience. We really appreciate it. Nathan, it's great to see you. I'll talk with you offline. But everybody, have a great rest of your day wherever you're at, and we'll see you next week. Take care.